also brought out, Jeffrey, that in one of the articles he used the term OBM, one big mistake, to reference these types of incidents by law enforcement where the consequences are lethal. And in that article, he did say, according to his testimony, that some of the OBMs, one big mistakes, are preventable, and that certainly preventable is better than follow-up. I thought she might go further along that to say, so it is preventable. It's not, but she kind of left it there. Do you think that's a good strategy on her point?
Well, I think he's been very difficult with her. And the so question, when you don't know the answer, is one you avoid. And I think that's why she did it.
All right, back to court.
The objection is sustained.
Dr. Miller, just a few more questions. You reviewed video in this case, correct?
I'm sorry?
You reviewed some video in this case?
Yes.
And you'd agree that the defendant's handgun was just inches below Officer Lucky's face when she fired?
The objection is sustained.
Nothing further, Your Honor.
Is there redirect? Or
A couple of questions for you, Dr.
Sure.
Miller. Okay. Despite training in error avoidance and error detection in the industries that you've studied, action errors still happen.
Yes, we can't control every circumstance.
In medicine, for example, how many errors occur, how many deaths occur every year as a result of action errors?
Objection, lack of foundation.
If you know.
the objection is overruled. You may answer.
According to one source, over 1 million a year. These don't necessarily involve serious injury or death, but just errors that occur in which an adverse outcome does occur.
And this is a profession that is highly trained to know that they can happen, and they still do.
I mean, I'm not an expert on medical procedure, but that would be a logical assumption.
And they still occur where there's a great deal of training involved.
Yeah, I mean, the broader point is it's unrealistic to expect zero errors in any profession. Our goal as responsible professionals is to bring that number as low as possible.
But it still happens. Yes?
I'm sorry?
It still happens, though.
And so far, they still happen. But again, that doesn't relieve us of the responsibility of still trying to reduce how often they happen.
Thank you.
Is there any recross?
Briefly, Your Honor. Dr. Miller, you testified that there are many action errors that occur in medicine, correct?
That's my knowledge, yes.
How many of them are fatal errors?
I have no statistics on that. I don't know.
How many planes fall out of the sky every day?
Fortunately, very few.
Nothing further.
Anything further? Okay. Thank you, doctor. You may step down.
Thank you, Your Honor.
All right, members of the jury, we're going to take our morning break, so 20 minutes.
The first witness of today, day 8, has completed his testimony, and the jury's now been excused for a 20-minute morning break. Will Kimberly Potter be the next witness to testify? We'll bring you live coverage here on Court TV, the front row seat to justice. Welcome back to Court TV Live. I'm Ashley Wilcott. Happy you're joining us. Minnesota is on a 20-minute recess in the trial against Kimberly Potter. She is the one and is expected, rather, to testify this morning as soon as the court does return from that brief recess. The defense's first witness this morning was a psychologist, a forensic psychologist, Lawrence Miller, and he told jurors about the concept known as action error and how it applies to high-stress environments, including law enforcement.
During an action error, I think you touched on this, as the individual involved realized that the error is taking place at the time it's taking place.
I'm sorry, could you repeat that, please?
When an action error occurs, does the individual who commits the action error understand that the action error is taking place when it does?
Well, that's what makes it an error. During the action itself, the person thinks that they are performing one action when they're performing something else. Typically what happens is when the intended result does not occur, they realize the action was an incorrect one. But while they're doing it, they think they're doing thing one while they're doing thing two.
So what are the factors that would contribute to an action error in a law enforcement setting?
Well, any situation that involves an extreme degree of stress, which usually means a threat to life. We mean by a critical incident, we mean an incident where there is some credible threat to the safety or life of a police officer, of a citizen, of bystanders, and that requires an immediate response. Critical incidents don't only occur in law enforcement, they occur in medical, emergency room settings, they occur in firefighting and first responders. But here we're applying critical incidents to law enforcement. And in those cases, the factors usually involve an extremely compressed time frame. The person has to act very quickly, sometimes instantaneously. There is that high threat to life and safety. Often there are confusing and changing circumstances. The circumstances may be ambiguous. You're in a scene and you're not quite sure what's going on, and what's going on may change from second to second. And put all these things together, and this creates a high state of arousal and agitation, and that is exactly the kind of perfect storm for the production of an action error.
Here to help break all this down, criminal defense attorney Jeffrey Wolf in Denver, Colorado, here as a guest legal analyst. All right, Jeffrey, I want to start at what happened most recently and then go backwards to that testimony, because after the forensic psychologist Dr. Miller finished his testimony, we heard from the court outside the presence of the jury. And here's what she said, was that her prior ruling was no expert would be allowed to testify as to whether or not Kimberly Potter engaged in a slip and catch error. Does it surprise you, number one, that that was the ruling of the court before we even got started with this trial?
No, it doesn't surprise me, because what that means is that at some sort of evidentiary hearing, the defense was unable to put on any sort of evidence that somebody was able to ascertain that, and the prosecution was the same, not able to show that somebody disproved that. And the reason that that does not surprise me is because of the cross-examination of this witness that showed that this particular concept is basically his and his alone. And there just isn't enough data to make it scientifically reliable. Quite frankly, I'm surprised they even are letting it come in at all, much less applying it to the actual case.
And that goes to your point that a few minutes ago you shared with us. You felt like the prosecution on cross-examination was doing a very good job bringing home that point, that this is not something widely accepted in the industry. To that end, are you surprised that we also just learned that the state does intend to call a rebuttal expert to talk about this slip and catch error?
No, I'm not surprised by that either. I think that, Ashley, what we're seeing here is they are going to hammer home that this expert that the defense is really going to hang their hat on is coming up with junk science. So what they're going to do, as my guess, is call somebody to say, no, This guy is a quack who's looking at what he wants to do for his particular subset of clientele, which is law enforcement, and he's making it up. And that this is not widely accepted. It's not peer reviewed. It has no basis in actual science. It is convenient and it sounds good, and they're trying to trick the jury with it. I think that that's what they're planning to do.
All right, Jeffrey, I just want to confirm you are a criminal defense attorney, right? You do represent criminal defendants? No, I'm kidding.
I am.
All right, I'm
I am.
facetious. But to your point, I think that the point that you make is so well made that it doesn't matter which side you're on. When you have an expert like this and you have experience trying cases like you do, that the quality, that the credibility of the expert and all of the underlying science is the important piece of it as to whether or not it's something a jury's going to believe.
Well, and the really important part to understand about this is that this is a very rare case where this type of expert testimony is coming from the defense. These experts have been around for decades, but the law enforcement is usually on the other side. And so the prosecution has been banging the drum for experts like this guy for decades. And it just so happens that there is a sea change in this country, and now these experts are finding themselves on the defense side. And so, yes, I am a defense attorney, but I am as angry at these experts testifying for the defense as I have been for them testifying for the prosecution for my entire career, because I know their junk science, they know their junk science, law enforcement knows their junk science. Quite frankly, the judges know their junk science, but everybody's afraid to say it. And so it's nice to see a prosecutor do it.
And I think juries see through it too, as well, in my experience. I want to listen together because let's listen how Paul Ng, who again represents the defendant as one of the defense attorneys, in his opening statement talked about action error and how it applies with Kimberly Potter.
And finally, we're going to answer the question that some of you had. Well, if you're a police officer for 29 years, why and trained so well, why should something like this happen? And so we will be calling a fellow named Lawrence Miller from Boca Raton, Florida. He's a PhD in psychology with an expertise in traumatic incidences and police work, violence. And he's going to talk to you about how it is that we do one thing while meaning to do another. And it's called in the literature an action error. And he'll come in Friday morning, a week from this Friday, and he'll talk about the routine kind of action errors that we all experience. Give you some examples of what an action error is, but I want to get that word in your mind as you go through the case, action error. And for example, as the year turns, and for those who still write checks, you write the date of the check in January and you put the wrong year because you're used to doing 2001 all through the year and it should be 2022. Well, that's an error. You're making an error you don't even think about. Or in computers, you change the password but absentmindedly go back to your old password. Or if you've recently moved to a different location, you sometimes can drive back to your old location not realizing that that's what you've done. These are called action errors, and they are ordinarily dismissible, but they become quite important when what happens is catastrophic. And when someone makes a mistake and wants to do one thing but does something else with consequences of the kind that we see here.
So, Jeffrey, we did hear that expert give that example of when you write a check in January and you put last year's date on it. And I think that we can say most of us have probably done that. So when you break it down to that simplistic explanation, it almost makes good sense.
Well, it's just good storytelling. That's what opening is, right? Tell the story of the case. And he knows the questions he's going to ask. He knows what the expert is prepped for. And so it works. And that simplicity does work. But writing a check is not shooting somebody and killing them.
All right, Jeffrey, I always appreciate your expertise. You're going to stay with us. Up next, we'll take a closer look at the defense team's opening statement for other clues as to what Kim Potter might tell the jury when she testifies today. when she pulled her service weapon instead of her taser during a traffic stop and killed 20-year-old Dante Wright. Court TV anchor Michael Ayala takes a closer look at what we might hear later today.
This was an accident. She's a human being. But she had to do what she had to do to prevent a death to a fellow officer, too.
Jurors are getting two different versions of Kim Potter during her manslaughter trial. Prosecutors have painted her as a very experienced officer who made a criminally reckless mistake, making it worse by failing to help Dante Wright after she shot him. However, when Potter takes the stand, the defense will be sure to key in on Potter's reputation as a well-respected officer who's been interested in policing since grade school.
One day in her grade school class, a police officer named Michael McGee came to talk about bicycle safety. And it is amazing what influence an adult might have on a child at any particular time, but she enjoyed the talk, and it dawned on her that she might want to be a police officer.
In a further effort to humanize Potter, the defense will likely have her tell the jury how dedicated she was to her family while trying to balance home life and career.
Kimberly Potter, she's 49 years old. She married her husband, Jeff, who's the fellow with the dark suit. And they have two kids. One's in the Marine Corps now, and one plays the Division I hockey in the Dakotas. And she'll tell you one of the proudest days of her life was to have her dad pin the badge on her so that she could be a police officer.
If you listened closely to the defense's opening statement, there were many clues as to what Kim Potter might testify to next. Undoubtedly, she will address her background as an officer, including a special interest in helping domestic abuse victims.
She shepherded the women through the court system, became their mentors, made sure they were treated fairly.
And Potter will surely tout how proud she is being part of a group that honors officers who die in the line of duty.
Her greatest achievement, she'll tell you, is that she is on the honor guard for police officers who die in the line of duty. She is the one among several who carry the caskets.
Once done with her background and career, it will be time for Potter to tell this jury exactly what she was thinking when she chose to escalate the use of force during the confrontation with Dante Wright.
She never fired a gun. She never fired one shot. She never fired her taser. She never had to. She was good at de-escalating everything, and here that's what she's trying to do. And she'll tell you this, then when she says taser, 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 if she does nothing, Mr. Wright drives away and either substantially harms Sergeant Johnson or, more likely, he kills him.
It's likely Potter will be emotional on the stand. She's been emotional throughout the trial, and her emotions at the scene of the shooting are well documented on video. Shortly before the trial began, in an interview with the Minneapolis Star, Potter was described as crying as she recounted her constant struggle with the events surrounding Wright's death. She's quoted as saying, "I'm a good person, and I valued him in life. The aftermath of that day has destroyed me. I pray for the Wright family every day." During openings, prosecutor Erin Eldridge told the jury Potter betrayed her badge and she failed Dante Wright.
She betrayed a 20-year-old kid. She pulled out her firearm, she pointed it at his chest, and she shot and killed Dante Wright.
When Potter takes the stand, she will undoubtedly face rigorous cross-examination by the state on both her thought process on the day of the shooting and her alleged violations of department policy.
Still with us, Jeffrey Wolf. Jeffrey, I haven't had a chance to ask you your thoughts about the fact that Kimberly Potter intends to testify. Do you think is that an obvious, or do you think that she's taking too big of a risk by taking the stand?
I think it's pretty obvious. What she did is on video, so it's not like she has something to hide here, but they have everything to gain from her testimony. It is to humanize her. It is to show regret of what happened and to let her explain in her own words what was actually happening. When something is on video, it is time for the defendant to explain it. The same thing happened in the Rittenhouse trial. It had to be done. And it is really her best shot. It is to make the jury see her as a person and not just as another officer who killed another black man, because that is, quite frankly, how this case was originally framed, and her defense is doing everything they can to try and not have it remain in that box.
And do you think that that is going to be the difference between first degree, second degree manslaughter conviction, or do you think by testifying, does she really have an opportunity for an acquittal in this case?
Well, they better be going for an acquittal. I think that that is absolutely what they're shooting for here, and it is what the defense has been aiming towards. They have not been aiming towards this wasn't reckless, it was negligent. They have been aiming towards this could have happened to anyone, and it does happen all over the world in different industries and to different people. That is what they're shooting for, is that it is a mistake, and it's a grievous mistake, but it's not a crime. So they are shooting for acquittal 100%, and this is their best shot, is to have her humanize this situation so that the jury can see for themselves what really happened from the person who actually did it.
All right. Jeffrey, I want to see if we can bring back up a picture of the courtroom. I understand the judge is back on the bench. Just a reminder, it was a 20-minute break, a 20-minute recess. We do see that she's entered the courtroom. I don't know that we have audio yet. Let's listen in.
If Officer Potter testifies inconsistently with what she said to Dr. Miller, I think it's fair game for the state to call Dr. Miller to testify, okay? That is not going to open the door to the defense asking the ultimate question. I just want to make that crystal clear, okay?
So I know, Your Honor, if they ask questions on that report, did you say this? Did you say that? And now the jury knows that she was interviewed by Dr. Miller, and they're going to wonder what the diagnosis was. We never mentioned that she was interviewed by Dr. Miller. That opens the door, doesn't it?
No, because Mr. Gray, that would just be pure impeachment of her factual testimony.
Okay, what happens if she says, no, I didn't say that? It was on a Zoom meeting, and it wasn't recorded, and she says, I didn't say that. And then they recall Miller. Does that open the door?
No, because it would just be pure impeachment of
Well, now we
her
have it.
factual testimony.
Well, now we have a situation where he interviewed her, he wrote a report, and they're going into that, and we can't show the result of his interview and his report, even though they're going into it. That's not fair to the defendant, Your Honor. Totally not fair.
Well, Mr. Gray, that's my ruling.
Okay, I just wanted to make sure I didn't make any mistakes up there.
Okay.
I don't want to do that.
All right. Okay. Let's get the jury.
Your Honor,
okay?
before we do that, if it is the defense's intention to call the defendant at this point, I think we have to make a proper record before that happens.
We already did.
I think I already asked Officer Potter whether or not she still wanted to testify.
I would just confirm that as of today, I would just make an additional record, Your Honor.
Well, is your decision the same?
Yes, Your Honor.
Okay. Thank you.
The jury is on the way back into the courtroom, and there you heard it, Kim Potter still intends to testify. That's it for me today, but coming up next, Julie Grant to help break it all down and bring you the latest. This is Court TV, your front row seat to justice.